Hi, everyone. Hi. Welcome back. Welcome back. How's everyone doing? Good? Good weekend? All right, very well. Let's see. Anyone have any questions from the last class? Remember the haunted house case and implied warranties, any of that stuff? Any questions? Yes, sir.
Can you just go over the whole thing again? I missed.
There's a video for that. Okay, got it. Anyone else who was here? No, I don't mind if you're absent. Just watch the videos. They're actually they're perfect replicas of what happened in class. Although the only caveat is I often wander off camera, so you're staring at a blank screen, which is kind of awkward. But I'll try to stay in camera if I can. Any other questions? Okay. So today's class continues our discussion of contract of sale. If you'll recall, the very first day we had this topic, I gave you that very long contract with lots of different clauses and provisions. And I told you the most important aspect of that entire long document was what's called the implied warranty of merchantability, good and merchantable title. And this is a term that you're maybe familiar with from contracts class. Okay. In the next class, we discuss, well, what happens when there's something that isn't in the contract? And we had this silly case of the haunted house, right? And we asked, are you required to disclose that the house was allegedly haunted or that the house had a purported murder in it, things like this, right? So generally speaking, the common law doctrine was caveat emptor, buyer beware. That is, the buyer is responsible for doing whatever research and due diligence that must be done. An exception for this, though, concerns what are called latent defects. A latent defect is a defect that is not obvious, and the classic example is a leaky roof or a cracked foundation, right? These are things which a reasonable inspection may not turn up. You will only know if a house has a leaky roof when it starts to rain really hard. You may not know that a house has termites until things start falling apart. You may not know that a house has a cracked foundation until it starts sinking into the ground. Right? These are latent defects. And courts say that, generally speaking, you can't misrepresent latent defects. But what happens if I stay quiet, right? You don't ask me if there are any latent defects, and I stay quiet, right? Under the common law, as long as you don't lie, you're fine. If I ask you, is the roof leaky? And you say no, you lie. Okay, that is a no-no, right? You've just breached the warranty. I can get my money back. But if I stay quiet and you don't ask any good questions under the common law, well, in that case, then you win, right? The seller has no obligation. But that common law trend, my friends, is on its way out. We did that case in Florida where the court basically said if there's some sort of latent defect, it's in the knowledge of the seller, he has to disclose it. It's not enough for him to stay quiet and avoid liability, right? He actually has to affirmatively represent that the roof has a leak in it, if he knows. Okay, so what you're seeing here is a demise of the caveat emptor doctrine, right? The book says it's maybe on life support or something. That's probably a good estimate, right? Traditionally, under the common law, people are responsible for doing their own homework, their own research. But today, courts are not willing to put that burden on the buyer. Indeed, it's the seller that's responsible for disclosing anything that might be wrong with the property. And for the most part, if you have the standard sales contract, I showed you the Texas one, I showed you the one in the book, it has all those things in it, right? You need to disclose, are there foundational issues, right? Are there latent defects? You need to disclose them. But what happens if you don't use one of these contracts? You're not required to, okay? It's here that the courts often step in and say, even if you don't put these terms into your contract, we'll do it for you. The courts will insert these protections for you after the fact into your contract, even if you did not negotiate for them in the first place. Okay. Any questions on that doctrine? This is all we covered the last couple classes. It's a little overview. And again, if you didn't get the overview, you can go back and watch the video again later. It's all there. I'm actually on camera this time. Any questions on that? Yes, sir.
Does this kind of motivate the seller to just be ignorant about any defects? I mean, obviously you're going to know about a leaky roof.
Well, if the seller doesn't know the roof is leaky, could he ever lie about it?
I'm just saying the next gap, I feel like, is just this: the seller is going to willfully be negligent.
Just
willfully
be
ignorant
dumb. Don't pay attention to his property, right?
or it's
Well,
not inspected.
So let me ask you, I'll ask you a question back, Tyler, right? How do you think the New Jersey Supreme Court would handle a willfully ignorant property owner who, like, oh man, is it raining or something? I don't know, there's water dripping my head, right? How do you think they would handle a property owner who willfully doesn't investigate why water is leaking through the roof? Take a guess.
Well,
New
because
Jersey Supreme Court.
Jersey,
Yeah.
Probably side with the seller.
With the seller.
Or no.
No, Tyler, think about it, right? How do you think a modern court that dislikes caveat emptor,
Modern court. Sorry, everything we've done with New Jersey has always been
everything New Jersey is getting rid of the common law?
Gotcha.
So how do you think
Yeah,
a
so
modern
I'd say
court
if
like
you
New
know
Jersey
training,
would handle it if a seller was willfully blind? Think about it.
just ask them, like, was there puddles in your house?
Oh, they're not going to ask anything. You're smirking. What do you think the answer is?
Oh, they'll use the standard knew or should have known.
Yes, exactly. That's even better than the answer I was looking for, but that's good, right? They'll say either the seller knew or he reasonably should have known that the roof had a leak. I mean, if there's evidence that every time there's a big storm, water would start coming through the ceiling, and for whatever reason the seller never bothered hiring a contractor to inspect it, okay, maybe he was being reasonably ignorant, right? He was deliberately trying to ignore what was going on. And I'm sure courts would impute that duty. That's an easy one.
The heart of my question, though, is are the courts going to start get to the point where the sellers have to have it inspected? I mean, obviously, you're going to know if you're
Well,
leaky, but
let's
are you going to know other
ask me this question again after you do the first case, the Lempke case, because it's a slightly different fact pattern, right? Because it involves not the seller of a house, but a contractor. And one of the questions is when a contractor does a roof, is a contractor obligated to know that he did a bad job and that the roof be defective? You see. Okay, let's do the first case then. Where did I wrap up last time? Who was last? Come on, it was only 3 days ago. Who was last up?
You guys like
Did I call on you? Did I call on you? Did I call on you, Omar? Okay, Omar, you're up. Last, and then we'll hop back over to the other side. I always go the same direction. I try to keep it consistent. Okay, Omar. Lempke versus Dagenais, a New Hampshire case from 1988. What were the facts here? What was the problem here?
The problem was that Lemke purchased the home from the predecessors who had contracted with English
Okay.
to construct a garage.
Okay.
And what happened was, when he moved, 6 months later, they sell the home and Lemke moved in. He noticed that the truss was in.
What's a truss, by the way? I didn't know what this was when I first read this case. Do you know what a truss is?
It's on there. On the inside, I don't know what it's.
So ever know like Whataburger is like an A-frame, right? I text to give you examples. Basically, the things holding the roof up. Those are the trusses that are holding it up in that kind of shape. Okay, so continue. What happened to the roof of this garage that was built?
Well, he noticed that it was getting new work.
Why? What was wrong with it? What was the problem?
It was caving in.
Yeah, basically the frame holding up the roof was caving in. Okay? So Omar, let me ask you an easy question, right? What happens if the original owner, right? The original owner went to the contractor, Dagenais, and said, hey man, you did a terrible job with my roof, right? What could the original owner have recovered in this case?
Repairs.
Yeah. Would he have had to pay for it?
No.
Who would have had to pick up the cost in that case?
The contract.
Why would the contractor have had to pick up the cost if he was dealing with the original owner?
There's an implied warranty.
Yeah.
Called it workmanlike condition.
Exactly, right. So this is a straight up a contracts case that you have studied last semester. I'm not even sure what's in the property book, but it has enough connection to the topic. If I go and I hire a contractor and I ask him to build me a roof and he does a bad job and the roof starts caving in within a couple months, right? I can go to that contractor with whom I have a contractual relationship with and say, okay, you screwed up, fix it. Build me a better roof, I don't care, but fix it. I can't have this. Okay? Now, Jimena, what aspect of that relationship allows me, the buyer, to go right to the contractor and ask for the repairs? What aspect of that relationship? Exactly. What is previous contract?
That they're contracting with each other, that they're connected with each other.
Exactly right. The original owner is what's called in privity of contract. The original owner and the contractor are in privity of contract. And she said a second ago, privity means a contractual relationship. Let's do a mini review, Michelle. Where have we used the word privity before in this class? We only have 5, so or actually 4 at this point. So you have a pretty good guess at which topic it was.
Adverse possession.
Yes, exactly. Where does privity come into play with adverse possession?
The person who's adversely possessing probably doesn't want to be in privity with anyone going to assert his own ownership. Otherwise, it doesn't have to be.
No. Close. Dasha, do you remember? We've only had 4 classes, so I always mention this point at class 5. Whenever I get to this point, it's like, okay. Anybody remember? Yeah.
Where the 2 different squatters have privity, so that they can combine.
What do we call that combining? Tacking, yes. Exactly right. When squatter A is there for 5 years, then he makes a contract with squatter B, who stays for another 5 years. They can add it up together, and they have 10 years, and they can acquire through adverse possession. The reason why they can add the time together is because they're in privity. Remember the example I gave where squatter A was there for 5 years? Squatter B comes along, throws them off the property. They are not in privity, and they cannot tack on their time. Remember that? Okay. So we'll go back to Natasha. Natasha, so we have this situation here, right, where the original buyer, the original owner sold his house to Lempke. And then Lempke discovers it's caving in. What does Lempke try to do at that point?
Well, he wants to establish that there becomes something necessary.
No, before he gets to the court, right? What does Lempke do before he even goes to court? You're right. Everything says correct, but we're not there yet. What do you think Lempke did? What do you think the buyer did? Yeah. Yeah, he asked him to repair it, and what did the builder say?
He said he agreed to, but never completed it.
Why do you think he never actually completed it? Come on. Why do you think the builder never bothered to fix it? You were his lawyer, right? You're his lawyer in New Hampshire, 1987, whatever year it was, right? And he walks into your office and says, hey, this guy, Lempke, I don't know who he is, but he bought the house from the other guy. He wants me to fix his roof. Am I obligated? You're his lawyer. What do you say? That's right. Why are you not obligated to fix it? What's your advice? Exactly. So everyone's seeing this, right? For like hundreds of years in New Hampshire and elsewhere in America, if you were a contractor, right, and you went to your lawyer and you asked him, do I need to fix this roof? Not from the person I sold it to, but from some other guy down the road. Your lawyer says, no, you don't have to do it because of privity. So everyone sees what happens when you change common law rules. We'll get there in a few minutes. When you change common law rules, the client, a year later, became incorrect. Now, can we sue her for malpractice? No, she gave correct advice at the time. But the contractor relied on what the law was. Okay, so they asked to fix it. Contractor says, no, not going to do it. So then the plaintiff sues. Okay, so Peter, how does this case turn out under the common law rule? Under the common law rule, how does this litigation go?
The plaintiff bringing who now own the garage would win.
Is there privity in this case?
Here they say yes.
No. I'm not saying it what the court does. Is there privity in the traditional sense between Lempke and Dagenais?
No.
That's correct. Why is no privity?
Because that's not the original owner.
Yeah. So under the common law, forget about what the court does here. Under the common law rule, does the builder owe a duty of workmanlike quality to a subsequent buyer? That's right. So under the common law, no duty to a subsequent buyer for workmanlike quality. Everyone understand that? No duty at all. Okay. But he sues anyway, right? He's like, I don't know, let's roll the dice. Maybe the court will change its mind. Now, what makes this odd is that only a couple years earlier, in the Ellis case, right, the New Hampshire Supreme Court had ruled that the subsequent buyer does not have privity, and that the subsequent buyer does not get the benefit of this warranty. But again, this was a common law rule. Now, we all know the outcome is they extend the protections to the subsequent buyer. But more important than the conclusion is how they get there, right? Stephen, what's the rationale for why this court abandoned the common law rule? And I gave you the answer at Kutzin. What's always the answer when a common law rule is being abandoned? It's a one-word answer. Oh, come on.
No, I know.
You remember I said it though, right?
Yeah.
Remember I said don't forget. Okay, what's the word? One word. What do you think it is? Good, fairness, right? Fairness. Unjust is good. Close second. Okay. Whenever any court, including this one, confronts a common law rule that was structured on certainty, right? It's an easy rule to apply. Either you're in privity or not. They reject that rule out of concerns for fairness. Right? Fairness. All right, so Peter, finish it up. What's unfair? What's unjust, to use your word, about this common law rule? Oh, I'm sorry. Yeah, sorry. Yes, here. No, Stephen.
Can you repeat it?
Stephen, sorry. Had to mix up. Stephen, what is unfair about the common law rule at issue here?
Well, because the subsequent buyer gets a house where they didn't know there was a defect, and even the original buyer didn't know. And it all goes back to the implied warranty. Work on my fault.
Now, let me ask you another question. Actually, we'll move it. You're good. Ben, let me ask you this question. Is this fair to the contractor? Is the common law rule fair to the contractor?
In a way, because the court discusses to prevent unlimited liability on the contract.
Good. Well, what do you mean by that? Limited liability? There's only one roof.
Well, meaning that I think it goes into the narrative of reasonable time, but how long can further buyers say that this roof has a latent defect?
Okay.
So when it protects the contractor from an unlimited blast for an unlimited time period.
What happens if they built the roof for a person who's 18 years old, and that person lived in the same house the rest of his life, so he's 90? That seems like a really long time. We're liable, doesn't it?
Right.
What's different here? Why is this different then?
Well, I don't think that there was, well, I don't remember what happened, but it wasn't something like that. It was that there was actually an issue with the roof, and it wasn't for normal wear and tear.
No, you're not answering my question. What's the difference between one person owning the house for 90 years and, say, 5 families owning over the course of 90 years?
Oh, well, like the time, obviously, the time frame.
It's still 90 years. Same period of liability.
Well, okay, so anyone along the line of the 5 families over 90 years can point to the problem and still on the hook for the 5 families, although it occurred however long ago.
Caitlin, what do you think? What's the difference from the perspective of the builder between one person owns it for 90 years and then 5 subsequent families own it for the same period?
Well, if you're talking about common law, then you still have to be a contract with that one person.
And specifically, does a builder have to take a contract?
No.
Why does a builder choose to take one contract and not another? See where I'm going with this? Ben, you want to try it again?
Okay, so I see what you're saying. The reason he took the contract was for a contractual exchange. He gets paid
With whom?
With the person he built the roof for.
Specific person, okay? This is something that may not make a lot of sense today, but generally speaking, if you're a builder, you may take a job with someone because of your relationship with them, right? And you may adjust the price accordingly. The builder was friends with the original guy, and the original guy said, hey, listen, I need you to build me a roof. And he's like, okay, fine, it's 10 grand. He's like, listen, I can't afford $10,000, right? Can you do it on the cheap for me as a friend? He's like, fine, I'll do an $8,000, but I'll use secondhand parts. Right? If you're making an arrangement with your friend, you might give him a good deal because you know what? He's never going to sue me. He's my brother, right? He's my best friend. But when you extend that to a subsequent buyer, that privity, that contractual relationship vanishes. So everyone sees the reason why this common law rule existed. It was to preserve the specific relation between a buyer and a seller, that matters. Everyone understand that part? Alex, was the court persuaded that this sort of close contact between the buyer and the seller matters?
What do you mean?
Do the court think it matters whether I sell a roof to you or I sell a roof to your subsequent buyer? Do you think they care much who is servicing whom? What did the court say about this? I don't think that's right.
But they owe a duty to a subsequent.
Why? Why?
Because it would have been something that would have been discovered.
No. Answer the question, right? Why is the court not persuaded there's a difference between the builder selling to person one or person two? Why does the court think it shouldn't matter?
Is it because of the duty that the builder has?
Why should a sale not destroy that duty? Norma? Why should the sale not eliminate that duty? Right? You have the duty to the buyer. Why should a sale preserve that duty onto the second buyer? Good. Right. So what the court says here is the builder has this obligation no matter who owns it, within some limits, right? When you build something, you need to stand behind it regardless of whom you build it for. Effectively, the court discards the idea of privity. This thing I said where I'll build it for my friend at a reduced price to know he won't sue me, right? The court says that doesn't matter. When you build something, you have an obligation for everyone down the line within limits which aren't really defined. Okay? Everyone get that part? So they basically say privity of contract doesn't matter. And in fact, did you guys study this in torts a little bit too with product liability? Remember, so when car manufacturers first started selling cars, right? I would go to a dealership in my state. I buy a car in Texas, right? And that car would break down. Originally, who would I sue? Would I sue the dealership, whom I had a contract with? Or would I sue Ford Motor Companies in Detroit? I'd sue the dealership. And that makes litigation very difficult because the dealership didn't actually make the car, but you are in contractual relationship with the dealership. So in the context of torts, they abandon privity doctrine, right? I'm sure you see these cases already in torts. They abandon privity. And they say, okay, you can just go ahead and sue Ford Motor Company because they're the true party in interest. There's a similar idea here. Even though the roof was built for one buyer, it's the same roof. And the duty you owe to the first should be extended to the second. And there's no reason to limit that duty, that implied warranty of merchantability. Everyone get that? Any questions on that? Dominique, so what's all of this business then about contracts and torts and these weird hybrids, these freak hybrids, right? What's the court getting at with how it's understanding the relationship between property doctrine and tort doctrine?
It wasn't implied warranty of its own thing, something separate from breach of contract versus the tort, because the type of damage recovery is different under each one.
You're right. I don't want to damage us quite yet. But generally speaking, what's the court doing in a property textbook talking about torts? What's it doing there? You're exactly right what you said, but let's do this question first. Well, we said just a minute ago, right? Torts doctrine evolved fairly early on in the 20th century, right? To eliminate privity. Dominique, why do you think the court here is looking to torts doctrine as a guide? Exactly. Here's the rub. Property law developed very rapidly in the 20th century. Very rapidly. What courts do, property courts, is they look to other doctrines and say, okay, you know what? If the law changed in this area, it should also change in our area. Even though, right? Even though property tort law is quite different, right? Tort involves, you know, one to another. Property involves real property, land. We're going to import the doctrine. So what you actually see in this class, and you'll see this throughout the entire semester, is an evolution of property law towards tort law. The key example in this case is the elimination of the privity doctrine. You'll notice in the last case with the haunted house, they kept citing Prosser, Statement of Torts, and duty to disclose. This is tort stuff that you studied in other courses. So I haven't talked much about the restatement of property deliberately, right? But there's a third and a fourth, but primarily there are two main restatements of property. Okay, the first restatement of property is common law rules, roughly stating. And the second restatement of property is shifting towards these more modern rules. There's actually a third restatement of property, and a fourth one is in the works, although no one even cares about it much. But the first and the second one are the big ones, right? So one thing which always throws students off in this class is you have to know the common law rules and the modern rules. Okay, and there's not a bright line one side or the other. But there's a trend, right? So if I say on the exam, whatever, apply the common law rule, in this case, you'll know, okay, there has to be privity of contract. If I say apply the modern rule or the second restatement rule, you'll say, okay, well, they're moving towards torts and they're eliminating the privity of contract requirement. And there's not a clear statement of one or the other. It's not like with torts, we have a first restatement of torts and a second restatement. This is much more fuzzy. But the general trend with the modern law is to eliminate all these harsh, unfair, unequitable doctrines that promote certainty. Okay? Questions? Everyone get that? Yes, ma'am.
Distinguish between the second and the third?
The third restatement, no one has ever adopted. Don't even worry about it.
Okay.
And they're actually writing a fourth reasons I don't understand, because no one ever. The thing is, almost every state adopted in large part the restatement second of torts to varying degrees, right? Some more than others. The restatement second of contracts from the UCC, those are pretty much standardized across the country. The restatement of property, no one's adopted it. None. In fact, in your notes, there's discussion of the ULTA, the Uniform Land Transaction, whatever, I can't remember what it stands for. Uniform Land Transaction, no one's adopted it. That's why I don't even bother remembering what it stands for. Property law is so distinct in each state because it refers to things that are not mobile. And when things aren't mobile, you don't really need to apply the law elsewhere. You only need what's the law here. So property law is very static in a given state. That's why if you're in New York or California or Texas, you did family law already, you see there's significant differences in how property is handled. Much to the chagrin of law students, it's not standardized. I can't give you what's the black letter holding for this in all 50 states. It does not exist. So I'll do my best I can along the way. Questions? All right. So, okay, so they abandoned privity, right? They say you do not need privy of contract to bring a suit by a subsequent buyer. But Josh, it's not unlimited, right? The court does try to put some limits on it. So I'll use the example I gave to Ben a minute ago, right? What happens if, I sell the house today, right? You sell to Dominique, Dominique sells it to Norma, Norma sells it to Alex, right? All the way down the line. Okay, then Alex then goes to the original seller 40 years later. I'm looking under the court's holding, the modern. So is there any limit whatsoever on how many people? Reasonable. How long is a reasonable amount of time? What does that mean? First become a parent.
Um,
You're right. You're accurately quoting the court's case. But I'm asking you, you're a trial judge, right? How long is a reasonable period of time?
This is all subjective on what the actual age is. If you move for that turnaround time, it might take a little bit longer than something wrong.
Yeah. Okay. And I like the way that you framed your answer, right? It depends. It depends on the nature of the defect and the issue on this property, right? It's not enough to simply say it's a 5-year or 6-year or 7-year or 10-year period. It's going to depend on whatever the factors are. And that's not a very satisfying answer, right? So is that Sam? Sam, let me ask you this question. You're the lawyer for the builder, right? And, you know, let's say Alex comes to you, and he's the 4th buyer in this line, right? You did this work 25 years ago. Actually, maybe it was your father, you know, your father-son business, right? And Alex goes to you, I want you to fix my roof. And you say, wait a minute, I sold this to like 4 people ago, 20 years ago, right? And you come to me, right? Lawyer, what legal advice do you give?
There to prove that defect was a result of your workmanship in this past 20 so many times in 25 years. That would be a very high burden notice.
Oh, good. But you said a key word. How'd you begin your sentence? You said exactly the right thing. What were the first few words you said? You don't remember. See, I listen to these answers. You don't, right? Who has the burden? You said it.
Oh, they would have the burden.
Who's they?
Plaintiff. The person trying to sue.
Okay. What's their burden?
They have to prove that the latent defect is a result of your workmanship. So basically, they have to prove that it's your fault.
And then what do you do as a defense?
Say that there's no way to prove that.
And how do you do that?
Well, there's been 4 different owners. You said it's been 25 years. There are hundreds of different theories you could show a jury as to what caused this, other than your workmanship.
Okay. You said exactly right. This shifts the way litigation works. Under the modern approach, the buyer comes in and says, wait a minute, you did a crappy job 25 years ago. And then like Sam said a minute ago, you say, no, here's what could have happened, wear and tear, age, whatever, right? But Ryan, what's the key difference from the builder's perspective between the common law rule and the modern rule? Just from the legal perspective, what's the key difference in how they defend this?
How they defend it.
Yeah, from a lawyer's perspective, what's the key difference?
That they don't have to put on a case that they did correctly.
Exactly right. Under the common law rule, there's no case. What's the entire defense in the common law rule? Exactly. Under the common law rule, all you have to say is, Your Honor, there's no privity, case dismissed, judgment for the defendant. But Ryan, under the modern rule, what's the case have to be? They have to prove and say, here, wear and tear, go hire an expert in material engineering, right? Go hire an expert in weather conditions. You have to put on a case. And this makes your life as a contractor more expensive and more miserable. Because rather than just dumping a case at a motion to dismiss stage, you actually have to go to trial on the factual issues. Everyone see the difference, right? By flipping it, by putting the burden on the defendant to actually show that the defect did not appear in a reasonable period of time, you're putting a significant litigation cost. Everyone understand that point? It's an important distinction, which is not anywhere in the case. But this, practically speaking, if you're a lawyer for the construction company, this is now your worst nightmare. Brian, your hand was up a little bit.
I thought, so the burden is on the defendant.
Well, be careful. The burden always is on the plaintiff, right? But the defendant has to rebut the burden.
Okay.
Right? So, excuse me. The plaintiff first shows this defect arose from the poor workmanlike quality, okay? If you're the lawyer for the construction company, you say, oh, no. It was because of wear and tear, natural conditions, etc. Right? But you now have a case you have to put on. Understand the difference? Okay, good. Catherine, your hand was up?
You answered my
Oh, I love when that happens. Good.
Thank you.
You're welcome. Everyone get that. It's an important point. Whenever you reverse common law rules, right? You're making it easier for the plaintiff. You're putting a significant cost onto the defendant. And the defendant very well may now say, you know what? Even if it's not my fault, I'm just going to fix it because I don't feel like going to court. You know what? I don't have the money to litigate this. I'm going to fix this roof. And oh, by the way, because of this, I'm going to make my services more expensive for everyone else. Right? What people don't realize about tort lawsuits is that rational actors behave rationally. If you know that you can get sued and you're going to have to pay all this additional money, you start charging more. Right? So whereas maybe you could have gotten the roof done for $10,000 in the first place, now they're going to charge $20,000 just to back themselves up in the event that they have to pay for it later on in life. Right? Or they'll buy insurance, which is costly, and that also increases costs. Nothing is free. Okay? If you remember nothing else from what I say, nothing is free. Every change in the law costs people money. When you impose a cost on a seller, the buyer absorbs that cost. Every legal rule making it easier for a plaintiff to recover makes stuff more expensive. Okay? If you remember nothing else what I said, everything has a cost. You cannot make things more. You cannot make things better without making it worse for others. It's frankly impossible. Now, it's not to say that it's wrong, right? Maybe these latent defects are so terrible that we should allow recovery for them. But we should not kid ourselves that these are silver bullets, that they help everyone equally. They frankly don't. Okay. All right. So any questions on the first case? Okay, the court goes through all these other rationales saying, you know, the builder is in the best position to know, and the builder should be responsible for his own, construction, you know, and all this other stuff. But ultimately, the bottom line is they say it's not fair, right? It's not fair that the intervention of a sale eliminates liability, right? Just because you sell it should not get rid of the liability. The seller should have the duty to subsequent buyers. Yes, sir.
They kind of talked about the danger of sham sales. Is that actually?
Explain, what does that mean, the danger of sham sales? I'm glad you pointed that out. It tickled my mind when I read it again.
So if under the common law rule, if I build a garage and I sell that garage to you so that you can sell it to someone else, well, now the privity of contract's broken, so I'm no longer responsible.
Do you think that's a common thing?
I mean, not now.
So let me repeat what he just said. So he says like this, right? In order to get around this implied warranty, I hire you to build something, right? And I immediately sell it to you, and that cuts off the liability. I sell it to you for $1, right? That struck me as such a silly reason to eliminate the doctrine. I can't imagine that's done very often. Usually when you build a roof for someone, you do it on their house, not to go sell it right back. Anyway, I didn't think that rationale was very persuasive.
One of the logical conclusions in tort law, as far as with the car dealership and car manufacturer, I mean, that made it really simple for car manufacturers to have no responsibility for the cars they sold, because they said, well, we sold it to the dealer.
Yeah.
I mean, considering the way houses are built nowadays by a lot of builders, major builders, DR Horton, no Scotts, I don't see why they don't sell it to some rep who simply sells it to someone.
Passes it right back. Yeah, I mean, I guess the court lists, well, there's 7 or 8 different reasons why they think this is a good idea. I mean, they all boil down to the word of fairness, right? Is it fair? Any questions on the majority opinion? Cameron, anything about the dissent intrigue you? Yes, that dissent. Always read. There are not many dissents in this class.
It's a small.
Yeah, you better have read. It's only one sentence.
He just says he doesn't feel like there's an adequate justification.
Right. So first of all, the court had addressed this in the Ellis case, a couple years earlier. And he's like, why are we in the business of just randomly reversing precedents that were just fine 2 years ago, right? People rely on it. When Natasha, as a lawyer, gave advice to someone, she was relying on what the law stated at that time. And there were thousands of other businesses in New Hampshire that just got a big bill. Oh, by the way, this doesn't end here, right? Imagine how many other cases, how many new lawsuits were filed saying, wait a minute, you told me you wouldn't fix my roof. I'm going to sue you under this new precedent. And guess what, buddy? We're in privity now, right? Even if you sold it to someone, this spurred a lot of litigation. Cameron, what else about the dissent maybe was interesting?
Well, I mean, he just says there's no.
Who's he?
adequate, a suitor who was on the Supreme Court.
Ah, yes, thank. Oh, is that so hard? Yes, yeah. There's even a note about it. Right. So this was actually David Hackett Souter, who was a Supreme Court of New Hampshire justice for about 7 or 8 years. I guess this is one of those opinions where people thought he was conservative because he wasn't willing to reverse the common law doctrine on property. But David Souter is most remembered for being appointed briefly to the Court of Appeals and then elevated to the Supreme Court by President George H.W. Bush. This was probably Bush's greatest mistake as a president and most long-enduring, because as a Republican, he could have appointed the replacement for William Brennan, who I'm sure you'll study is the liberal lion of the Supreme Court, who had more opinions on the left of center than just about anyone else. Souter could have replaced him with anyone, and he replaced him with Souter because his associate said, don't worry, this guy's a conservative. He's a stealth candidate. He'll sail through. And it turned out that Souter became a solid liberal vote and basically destroyed George Bush's Supreme Court nomination. The entire thing was a mess. But this may be one of the opinions that someone read and thought, oh yeah, Souter, he's good, he's conservative, right? Doesn't find implied warranty as a merchantability, so we can rely on him. This was a dismal mistake. Okay. Any other questions on the Lempke case? Anything? Okay. All right, so we discussed the implied warranty of merchantability that is no longer limited by privity. Next up, we'll talk about what happens if a sales contract is breached. So, Kaylor, generally speaking in contracts, and not specific to this case, but you've taken contracts, what happens if there's a breach in a contract? Good. Oh, I like the definition, right? Do you remember what liquidated damages are? Kind of. What are they? Nothing with water. Do you remember, Paul, what liquidated damages are?
Just something you can, it's like assets you currently have that you can run away.
No. You remember liquidated damages? Yeah. Yeah, go for it.
It's like a statement in the contract that has like a certain price of damages. You compare whether it's a penalty or not.
Oh, you gave me more than they wanted. Good. Liquidated damages means you state in advance. You write in the contract how much you owe in the event of a breach. And these are helpful because this way you don't have to argue about damages, right? You can say, if I breach, you pay X dollars per widget, right? Whatever it happens to be. So Paul, go back to you. Paul, what happens in the absence of liquidated damages and there's a breach? How is a court supposed to decide what the remedy is?
I guess just reasonable under the circumstances, based on whether the nature of the breach.
What are they measuring? You're right, but what are they measuring? Be more precise.
What is the court measuring?
Yeah, how can a court decide the correct measure of remedies if the liquidated damages are not liquidated?
Just the value of the breach.
The loss, right? The harm, right? Basically, what is the harm? And this is what we often call damages, okay? Now, is that Jessica? Jessica, what happens if there's a breach of a contract and the buyer doesn't want money? He wants the widgets. He wants the widgets to be delivered. What can a court do in that situation? Buyer doesn't want damages. He wants the widgets. Even if they're late, whatever, just give me the widgets, maybe with interest. What could a court do in that situation? I'm not there. I'm asking, remember, all the way back to contracts, right? What can a court do if the buyer refuses damages and wants the widgets? What can a court actually do? What do we call that? Yes, specific performance. What's specific performance? To do something, right? Exactly. Specific performance means do something, right? Actually convey the widgets. Now, I'm sure you studied in other classes that specific performance is disfavored, right? Haley, why do courts not like ordering specific performance? Yeah, we don't have in the American legal tradition a norm of forcing people to do stuff, right? We do not like specific performance, and maybe we do this in torts, but we do not have good Samaritan laws. Did you say this? Right? Everyone see the last episode of Seinfeld? Remember this? Okay. Remember what happened was Jerry and Elaine and Kramer and George are watching this guy getting robbed, and they're actually sitting with a video camera and taking a video of it, making fun of this guy getting mugged, right? Okay. They didn't help him. They said, oh, we don't have to help this guy. They're actually arrested in the town, New Hampshire may have been, under a Good Samaritan law. The idea is you have an obligation to help others. We do not have that in our legal system, right? I can watch someone drown and go, huh, that's something. And I have no legal liability. If I try to help them and I screw up, I'm negligent, okay, then I'm on the hook, but I can, oh, look, he's drowning, that's funny. No, we don't have that. So courts don't like to award and force people to do stuff. We don't have that tradition. But property is a little bit different. In property, specific performance is more palatable. Okay? Anyone want to take a guess? Let's see. Urvashi, why do you think property, as compared to contracts, courts may be more willing to order specific performance? What do you think about property may be different?
Because it's like a tangible asset, like you can just transfer it.
Well, widgets, right? If I'm selling widgets, why can't I force someone to sell the widgets? Make it easier, right? If I have a contract to buy from you, 50 iPods, right? And I don't want to sell you the 50 iPods. Why would the court not need to make me sell you the iPods?
Because I think I can get that from somebody else.
Exactly. Widgets are interchangeable. You can get the specific goods anywhere else. What about property?
Like only that one piece of land.
Yes, exactly right. Property is unique. Every lot is individual, right? If I want Blackacre, white acre will not suffice. If I want Blackacre because of whatever's on Blackacre, that's the only land that will cut it. So while generally in contracts, if I won't give you the iPods, fine, pay me damages, I'll go buy them somewhere else. iPods, widgets, they're interchangeable, not property. Every lot is unique. So in many respects, specific performance, even though it's a very violent remedy, right? It's a very violent remedy, can be used in this manner. So we've actually already listed, the book has 3 possible remedies in the case of a breach, and we already listed or discussed, I don't know depending what you want, 2 of them, right? So first we have damages, and we have specific performance, right? In the event of a breach, you can get damages, and you can seek specific performance. The third one is one that's more unique. Property. What's the third one? Is that Rachel? Exactly. Okay. The deposit. Now, what do we call the deposit? What's the term we gave to it? Do you remember? Was on that contract? What's the phrase we use for it? Be honest. Too honest. You know what? The earnest money, right? The earnest money, right? Scared stupid. So the earnest money or the deposit is held in escrow. Remember we discussed this escrow? You give it to a neutral third party, and they have instructions not to release until both parties sign off. Right? So if you go through the transaction, everyone's happy, both buyer and seller sell off, then they release the deposit from the escrow to the seller, and everyone's happy. But what happens if something goes horribly wrong, which is always what happens in our cases, right? If there's a book in our case, things went wrong, right? Everything went well, it wouldn't be in our book. We don't discuss well-functioning transaction properties. We discuss messes. So the deposit has to be depending on whether the buyer or the seller breached. And for now, we're just talking common law. We're not going to the modern approach. We'll talk common law for a second. Aaron, under the common law rule, what happened if the buyer breached, right? I make a contract to buy your house. We sign all the paperwork. And on closing day, I say, you know what? I changed my mind. I don't want this house anymore, right? What is your remedy as the seller?
The buyer changes their mind
The buyer says, you know what? I don't want to do it. I changed my mind.
on the day of the sale.
On closing day, like, you know what? Screw it. I'm not doing this. I want to live somewhere else. Well, what do you mean they don't? Can you force someone to buy a house?
Well, once they sign the papers, haven't they already basically
They didn't sign the last paper on the day of closing. They didn't sign the dotted line. Can you make someone buy a house? Let me ask you this. You're the seller, right? On the day of closing, the buyer says, I'm not going to do it. What do you think your easiest remedy is at that point?
probably just think that maybe put it down is easiest.
Well, but can you take it? Where is that money being held?
Probably not.
Do you as the seller have access to that?
You know, they're being held by the title company.
Exactly, and that's a key point. The seller can't touch the escrow. So what would you have to do to get it?
Show that they had breached.
Yeah,
There's an
Yeah.
agreement that they're gonna give it.
exactly, right? You go to a court, you say, here's the contract, they signed it, they breached, and then they forfeit the deposit. And you get to keep the deposit, whatever it is, right? Everyone see that? That's the easy one of the common law rule. Dagenais, let me ask you the opposite, right? I'm the buyer, you're the seller, right? We agreed, I put down $10,000 in escrow. On the day of closing, you say, you know what? I don't want to sell this to you anymore, not going to do it. Not going to do it anymore. What do I do then as the buyer? What's my easiest remedy at that point? Yeah, how do I go about getting deposit money back? I put in $10,000 to escrow. How do I get it back? That who breached? No, the who breached. Yeah, the opposite. We flipped it. Exactly. You say, did the seller breach? And then you get your $10,000 deposit back. Very often, the only money you're going to get back is a deposit. Because more often than not, you want to sell the house to someone else. And once you sell the house to someone else, you're really not in a position to get many more damages. I mean, maybe you can, maybe you can't. But the most common remedy of these three is the last one, deposit. That's more likely than not what you're going to use. Okay. So we'll talk about deposit more on the other case, the New Jersey case, which you know what's going to happen. You haven't even read it yet. But let's do the first case, Jones v. Lee from New Mexico. All right, Eduardo, what are the facts in Jones, please?
Well, the buyers appealed from judgment to find that the seller breached.
Okay, look, before we get to the court, start with the facts. What happened here? What was the dispute?
Well, there's a sale of a house in New Mexico.
What did it actually sell?
I'm sorry.
Who? Start from the very beginning. Who are the parties?
The Lee
Okay.
and Shannon and Sam Jones.
Okay, good. And what arrangement did they arrive at?
The purchase of a $610,000.
Okay, so the contract price was how much? You said a second ago?
$610,000.
Okay, good. Thank you, sir. Okay, so they reach a contract to buy a house for $610,000. Eduardo, let me ask you this question. Do we know whether that was a good deal or not?
No, not from the.
So, Eduardo, what's the difference between the contract price and the market price? Actually, you're good. Let me move on. Chris, what's the difference between a contract price and a market price?
What's going at the market or what's being bought at.
Are those always the same thing? So I'm sure everyone knows you can get a house above market price, maybe you get a bad deal, or you get a house below market price, you got a good deal, right? So the fact that they set this price at $610,000, Chris, do we know that that was a market price above, below? Do we know anything? Okay. And this is important, right? Why is it important? Because when you're calculating damages, you need to know, well, they sold it for this much, but here's what it's really worth, right? unless you know what the house is actually worth, you can't do that subtraction. So I had one case when I was clerking that was very interesting. It actually involved Detroit during a, this is 2009 or 10, during a foreclosure mess, where basically an entire house was foreclosed, right? The entirety of the block just walked away from their houses. And a court had to determine what's the fair market value of houses in a block that no one sold. In other words, how could you determine the value of an entire block of houses that people just walked away from? You're going like this, zero. It was actually complicated. They actually hired economists to try what would have the price have been. And you have to actually make very difficult determinations because you have to calculate the damages for the bank. But in this case, all we know is the contract price was $610,000. Okay, so then we know the buyers breached. They said they couldn't consummate the deal, right? And then Alexander, what happened next?
They found a new buyer for the house at a lower price of $540,000.
Good.
And they sold it. And they sued Jones for the difference between the price they sold it for and the old contract price.
Exactly right. So their initial instinct was like, oh, okay, I got this. This is going to be easy to figure out, right? We originally were supposed to get $610,000. We only got $540,000. Easy, right? Our measure of damage is $70,000. But Alex, was it that easy?
Yeah.
Why was it not that easy?
Well, because you're supposed to base it off you're supposed to base it off the market value.
Exactly. Okay, so Brian, do we know what the market value was when they reached the original contract?
Yes.
Do we know what the market value was when they sold for $540,000? Ryan, for all we know, maybe the market price was actually $540,000 here, and they were getting a bad deal. Is that possible?
Sure.
Everyone understand that, right? We don't know what the market price was. And in order to calculate the damages, you need to know this. So, Ryan, how can the parties go about determining what the actual market price of the house was?
You could either use the contract price or you can get an expert in to
Very good. But is the contract price going to be dispositive, going to always decide what the actual price is? Okay, everyone sees that, right? The lawyers here, I think, were probably being a little bit too smart for their own good. They said, oh, easy, right? 610 minus 540 is 70. Done. Give me 70 grand, right? But there's no indication that that was actually the fair market value. Okay. Also, they didn't have to sell it. Right? They didn't have to sell it. If the house was worth $610,000, they could have kept their $610,000 house. Right? Just because he sold it to someone else doesn't mean the damages go to their original buyer. Right? Because Josh, what did the sellers keep when there was a breach? What did they get to keep based on a discussion a minute ago? What do you think happens anytime the buyer's breach? What do the sellers get to keep?
The earnest money.
The earnest money, exactly. I think it was $6,000, whatever it was. There was $6,000 earnest money that they kept. And generally speaking, when you have a breach of a sales contract, that is a measure of damages, right? When the buyer breaches, you keep your deposit. You don't go and sue them for whatever the difference in price was, right? They were probably pissed. Like, man, we're supposed to have 610, we only got 540. Let's sue them. But really, they had their damages, which was the retention of the deposit. So the court basically said, let's remand. Let's send it to the lower court to find what is the actual market value of the home, and then they can subtract it. Let's say, Jack, let's say that the market price was actually $530,000, right? What's the damages there?
They just do the 10,000.
No.
Oh wait, you're still on the.
Yeah, the market price was only $530,000.
Oh yeah, then you wouldn't have.
Do they owe money back to the original ones? Right? So it's possible, it's conceivable indeed, that the market price was below 540, right? But Jack, what happens if a market price was 550? Then you get $10,000 in damages, right? So you actually have to decide what is the price, right? The difference between the actual market price and the price in the contract. Everyone get that part? Yes, sir.
What would they do if they went back to the trial court and they said, it was worth
like you said, it was worth 500,000 or 530,000, what would they?
You probably dismiss it and they'd be on the hook for attorney's fees because they were not a prevailing party. So basically, the sellers probably have to pay the attorney's fees to the buyers, and this went all the way up to the Court of Appeals. So those are a lot of fees. Yeah, generally speaking, I mean, you don't think about this in law school, but when you file a lawsuit, in many cases, the loser pays the attorney's fees. And if you filed an appeal, went back down, turns out you're not the prevailing party, okay, too bad. You have to pay up the fees to the other guy. So even if the damages only say $70,000, the attorney fees can be even more than that. Appealing a case is not cheap. Okay. Don't worry about the specific the special damages. It's not very important for this class. But once we have punitive damages, Brendan, what was the discussion about punitive damages?
Well, the issue was that they were, I guess, used fraud and trying to say that they had financial problems that weren't true. So are they also trying to, I guess,
Well, first of all, what are punitive damages? Everything says correct. What are
damages for going beyond?
what are the two types of damages? Punitive and what's the other kind? Exactly. What are compensatory damages supposed to do? It's in the word. Compensate, exactly right. Compensatory damages are meant to compensate for loss. So if indeed you lost $70,000, compensatory damages will pay you $70,000. Now, what do punitive damages do? Punish, right? They're called punies for short, right? Punitives. Generally speaking, punitive damages are meant to punish and send a signal. Now, do you remember, are there punitive damages in contracts? There are not. What about torts? Yes. Again, here, importation of tort doctrine. Traditionally, there are no punitive damages in property, but here the court very quietly imported the tort doctrine of punitive damages. Okay, Will, why were punitives deemed warranted in this case?
Because they talked about the way that they tried to get them recently.
Yeah. Describe what happened. There's some funny business going on here. What happened here?
They were claiming they couldn't get enough money, even though they had almost the whole amount in their checking account, as well as they had the income of $16,000 per month.
Okay, right. So basically, what happened here was they went to the buyers that, oh, we're broke. Please let us have this contract. Meanwhile, they were rolling in money, right? What do you think was going on here?
They just found a better deal.
They wanted to buy something else, right? It wasn't the case, but I suspected these people did a lot of real estate business. It wasn't. That was the sense they got from the facts. And the court said this was, quote, wanton, utterly reckless, utter disregard of contractual obligations, and they awarded significant punitive damages to persuade other people. So again, punitive damages are meant to send a signal, right? If you're a trial court now, you know that you can hit other parties with punitive damages to deter this sort of conduct. The punitives actually work to deter. It's an ongoing debate. Most people who act evil don't pay attention to the court reporters. They don't understand decisions. But at a minimum, the court thought that the punitives were warranted here. Okay. Any questions about this case? So effectively, here the court held that the correct measure of damages is based on the market price, which you have to determine. And don't worry, you got your deposit back. Plus, punitives were warranted. Any questions on the second case, the New Hampshire, whatever the heck this case is from, the New Mexico case? Well, today we have New Mexico, New Hampshire, and New Jersey. Hold the news. Yes, ma'am.
Yes, I have a question about the punitive damages because I remember in the contract law last year, in the contract theory, the punitive damages is not permitted in the contract unless there's some fraud or activities.
Hmm?
So here, because the punitive damages is permitted, is because of it has intention to consider his financial situation. Am I right?
Exactly right.
Oh,
Yeah, exactly right. So in contract doctrine, punitives aren't allowed, even when there's really, really bad behavior. But in this case, they imported from torts the doctrine of punitive damages, right? And they said because the conduct was so terrible, so egregious, that you can award punitive damages because we're trying to violate it. So it's funny, if this had been a contract for widgets, no punitive damages. But because of the contract for land, the court felt free to import the doctrine of punitive damages here. Everyone get that? Again, every case we do this semester, you'll see basically chipping away at common law doctrine and reaching into torts to bring in things to make stuff more fair. Because what happens if the purchase price was $530,000, right? The only damages they get is a deposit. That's all they get. So at least with the punies, they can get some more money and make it hurt for the defendants. Any other questions on this case? No? Okay, let's move on. The last case, Spencer. The last case, Kutzin versus Pimi. It's from New Jersey. What is the court going to do?
The court is gonna
I don't care what the facts are. What's the court going to do? It's from New Jersey.
essentially almost rule in favor of defendants.
No, I don't care. What does a court from New Jersey do?
Rules for the
No.
deposit.
No, you're not answering the question. Will,
Against common law.
they're going to reverse a common law rule. Write this in big letters in your notebook, right? If it's a case from New Jersey or New York, but usually New Jersey, they're about to reverse a common law rule without fail. I think I told you since second day of class, it's happened like 4 times already. And if anyone noticed, in the New Hampshire case, at the very end, when they said we can't file the common law rule, they cited a New Jersey case. Did anyone notice that? Without fail. All right, Spencer. So now answer the quickly. You answered the question correctly. So what were the facts in the Kutzin case?
So the defendants, the buyers, they contracted with the Kutzins for sell the house for $365,000.
Mhm.
They put $1,000 down. It's on signing and supposed to pay it $35,000 up next for the next 7 days.
Mhm.
There wasn't a liquidated damages clause or a forfeiture clause regarding the deposit. Pretty much they back on the deal.
Mhm.
Pretty much the contract only stated as far as somewhat of a liquidations clause. That if the contract is voided by either party, the escrow money shall be dispersed pursuant to a written direction of both parties.
Mhm. Okay.
And
Very good. Good. Okay. I'll stop you there for a second. All right. So before I get too far, the terminology in this case may throw you off because you probably never taught the difference. Vendor and vendee. I in law school could never remember what's the difference between the vendor and the vendee, or grantor, grantee, right? Who is who? I can never remember this in law school. And it wasn't until I took bar breed to study for the bar that they actually taught me a trick that always helps you remember who is the buyer and who is the seller. And the trick is this. You have to focus on the last 2 letters of the word, which are really the only thing that changes. Okay? Last 2 letters. Am I blocking it? I'm trying not to. When it ends in EE, you think of like me, it's the person receiving, right? The vendee, the grantee is the person receiving the property. Okay? When it ends in or, it's giving. So the vendor is giving the property, transferring the property. The vendee is receiving the property. The grantee is receiving the grant, okay? Don't confuse these because in this semester, we're going to do a lot of things like mortgagor and mortgagee, and the same exact rules apply. If you want, you can memorize it, but I prefer the device with the me, he, it, I don't know, helps me remember it. And throughout all of law school, I always got confused with this, and then for the bar, they finally taught me something that was useful, so maybe this will help you as well. Okay? Yes, ma'am.
Works with lessor and lessee.
Exactly. Yeah, it works with everything. Yeah, grammar. It's fantastic.
No, like if you're entering into a lease, the lessor.
Yeah. Lessor is giving the lease.
Okay. That's how I remember it.
Yep. Okay. And that's easy, right? All right. So what happened here, as Spencer mentioned a second ago, is that they the original purchase price here was supposed to be $365,000, right? So the contract price was $365, right? Then the buyers backed out, right? And Spencer, what were the numbers again?
So they put down 1,000,
Okay, so put down 1,000. Okay, so the earnest money was 1,000. Okay, what else?
and they're supposed to pay 35,000 days.
Okay, did they do that? Okay, then what happened?
The vendors ended up paying an additional 17,325 damages, renovations, damages, renovations, taxes, insurance, all within a 6-month period.
Okay. Wait a minute. So hold on. No, they did pay the 35,000. I'm sorry. They did.
After judgment, though, wasn't it?
No, but they paid the problem in this case was the payment of the $35,000 deposit, right? The deposit was $35,000 total. Sorry, you said, and I got confused in my head, right? The deposit was $35,000 total. The contract was breached. Okay, Jeffrey, under the common law, because the buyer's breached, what happens to that $35,000? Exactly. Okay. Under the common law, if the buyer breaches, the deposit's gone. They can withhold the entire thing. But Jeffrey, what were the actual losses to the buyer? I'm sorry, what were the losses to the seller as a result of this breach?
17,000.
Good. Where do we get that number from?
It's in the second paragraph.
Well, what was so the original contract price was $365, right? What was the resale price? How much did they sell it for?
They sold it for $365.
Exactly. Okay. So originally, and lost in Tate when I started doing math, right? But originally, they were supposed to sell the house for $365,000. Okay. They were able to sell it for about $12,000 less. Okay. So they lost about $12,500. Everyone see that? The difference. Okay. They lost $12,500. Been with me so far. And Jeffrey finished up. What were the other costs associated with the resale?
They made some improvements that they felt were necessary.
How much were those? Very good. How much were those?
Let's see. Some of the holding costs were about $3,825.
Exactly. Here we have the situation, right? And again, try and follow the numbers. They were supposed to sell it for $365,000. They only sold it for $352,000, so there was a difference of $12,500. There were also costs of $38.25, right? These two numbers, right? $12,500 plus $38.25. Okay. I'm sorry.
$3,800.
I think that include. Yeah. Okay. This number. Okay, let me get a calculator because I always screw this up in my head. I once tried doing this on in my head, and I screwed up. People were mad at me. So $12,500 plus $38.25, $16,325. Okay. So basically, as a result of the breach, they incurred $16,325 in damages. Everyone with me so far? Yeah.
We still need 1,000 for the carpet to.
Yeah. Okay. Yeah. Plus 1,000. Okay. Equals 17,325. Everyone with me so far? Okay. Good. So everything combined, they lost $17,325. Okay. Nali, where are the sellers going to get that money from? How are the sellers going to recover or get that money back?
They ask for the damage.
Are they going to be suing the buyers? Where are they going to get this money from? Well, let me ask you a question, right? You're the seller, right? And you just had that $17,000 in losses. What's the easiest way for you to recover your damages? Easiest way?
The easiest way is for the ask for the special damages.
Where's that money coming from, though? What's the easiest place to get it from?
Maybe the deposit.
Exactly, the deposit, right? If you are the seller, the easiest way to get your $17,000 back is from the deposit, right? You'd go to the escrow and say, okay, you know what? Release $17,000 and let the rest of it go back to the buyer. I want to see that. But that's not what happened here. Hold on, are you in the right seat?
No.
No. What's your name? Marcella. Marcella, that's not what happened here. What happens here?
No, they take a moderate approach, so they just get something.
No. What do the sellers try and do initially? Do they try and only exactly? So the sellers go to the escrow company and say, you know what? Common law rule, we get the entire escrow, and do they get everything initially? What does the trial court do?
Yeah.
What's
No, trial court says you get 17,325, the remainder goes back.
She's right. Okay, right. So the trial court, for reasons we don't know, says, wait a minute, I'm not going to follow the law, right? The law in New Jersey at the time was you retain the entire deposit in the case of a breach. But this is New Jersey where law doesn't matter, right? So the judge, you know what, screw it, I'm going to do what's fair. And the judge says, you can keep your $17,000 and what is the other $18,000, whatever, goes back.
Maybe the trial court just caught on and then you
They were ahead of it, right? They were ahead of the curve, right? Like, I know we're in New Jersey, right? And we know how this one ends. This one ends with us giving the money to the plaintiffs. Let's just cut the chase, right? Let's cut the middleman, right? So the trial judge like whatever, right? It was like whose lines in anywhere points don't matter, right? You know what? Well, it doesn't matter. It's New Jersey. So the trial court says you get to keep your $17,000 in damages, and the remainder goes to the plaintiffs, the buyers, right? Okay. Catherine, what does the Court of Appeals do who actually wanted to follow the law?
Court of Appeals.
Not the Supreme Court, the intermediate, the Court of Appeals.
The Court of Appeals reversed the trial court's
Yes.
failure to follow the common law.
The law, forget the common law. Yeah. Basically, the Court of Appeals is like, what are you doing? Follow the law. Under the law of New Jersey, it's been like this for a very long time. The seller can retain the entire deposit, right? Okay, so everyone understands what happens. It goes up on appeal then to New Jersey Supreme Court, and we know how this one ends, right? How does this end, Tyler? How does this one end?
Going to the Supreme Court.
Yeah, the Jersey Supreme Court.
Undo precedent.
They undo precedent. Okay, they reverse the common law. Okay, so what is the new law in New Jersey after they're done with this one?
That you can only take out of the deposit what your damages are.
Good. Right. They basically say you can only keep the deposit so long as it equals your damages. If your damages are less than the deposit, you're required to give the rest back. Eric, what's their reasoning? Why does the Jersey Supreme Court find it appropriate to abandon the common law rule about deposit?
I can't remember if they use the actual phrase, but it's basically unjust enrichment.
Good. Yeah, exactly. What's unjust enrichment? You did this in contracts or?
Well, unjust enrichment is when you confer a benefit on the other person that they don't deserve. And so in the interest of fairness, you can always bring an action for restitution if I've given you way more than you deserve. And that's the core concept here, is that
their damages are 17,000. The
Exactly.
excess is far beyond what they justly deserves. That's what
Exactly. So the action sounds an unjust enrichment. It's not exactly that, but this affects what you're saying. Listen, by letting them keep the full deposit, the sellers gained $18,000, right? The sellers benefited from the breach. You're not right. It's the other. Yolanda, what's wrong with the sellers benefiting from the buyer's breach? If the buyer's breach, why can't the sellers benefit? Why is that so unfair? Well, think about it, right? What's unfair about benefiting from a breach?
Well, you're getting the damages already. I'm not sure.
Want to try it, Alejandro?
I guess in this case, if there's such a big discrepancy, like between 17K and the 18K, that was from the 36. You can see what I'm saying?
Is there anything unethical, Alejandro, about benefiting from when someone else breaches? Right? Why shouldn't I be able to penalize the buyer when he screws up?
This means rescinding the contract out of good faith. You didn't mean doing harm.
Ah.
This one's getting.
Alejandro, what does the court say about penalties? What does the New Jersey Supreme Court say about penalties? Are those favored in the law?
No, it's no.
Why are penalties not? Want to try it, Yolanda?
Oh, it's okay.
Go back, yeah. What does the court say about penalties? You're still my line of sight, unfortunately. I'm sorry.
I'm sorry. I don't know. They just say it's not favored because
I think the quote you're looking for, penalties and forfeitures are not favored in calling an outrageous penalty more commonly in the damages since not resolved.
What does that mean? Why are penalties so bad? Why are they disfavored like that? You read the correct sentence. I appreciate that, but what does that mean?
I think you don't want to encourage people to breathe. You want to encourage people to stick to their original commitments.
No, it's the opposite. It's the exact opposite. What's an efficient breach? Did you say this concept? No. Well, Tyler, or sorry, Chase. What's an efficient breach?
An efficient breach is one where both parties are allowed to breach and we don't have to litigate over the damages.
No. You know what an efficient breach is? Remember?
Yeah, so a party can
Why would we encourage efficient breach? Let me ask like that.
gain a benefit, so
Yes.
they can breach the contract to get a benefit somewhere else.
Exactly, right? The classic example, right? I make a contract to buy a house from you for $1,000, right? I find the same house somewhere else, right, for $100. Am I going to breach? Probably not, because the damage is so high. But what if I have a deal to buy the house from you for $10,000 and I find it somewhere else for $1,000? I'm probably going to breach that contract and maybe pay a small penalty to do so. The idea is not all contracts are worth enforcing. And penalties force you to stick to a bad contract. Penalties force you to stay with an unfair contract that doesn't benefit you. So there's actually an efficiency doctrine saying big penalties are bad because they deter you from leaving contracts you shouldn't be in the first place. What's the response to that, though, Will? What's the response to that? What's the response to the efficient breach argument? Why should we not encourage efficient breaches? Tell Judge Posner why he's wrong.
Not trying to contradict the judge, but
Oh, it's very easy. Do it all the time. Why should we not encourage efficient breach? Why should we be?
they're still in your party then.
It's a promise. What's the value of a promise?
It's your word. If you can't do a promise, then if you can't do promises, then what's the point of
Exactly.
what economics is?
Yeah, exactly, right? There are these two competing schools of contracts I'm sure you study, right? There's the idea of a promise means your word. It's your honor. You're putting your promise in the line, right? And we should make people stick to their promises. That way you can rely. And there's the more economic model saying, no. we should encourage efficiency, right? Whatever is more efficient, we should do. We shouldn't force people to engage in contracts that make them worse off. So what the court does here by overruling the common law case, right, by overruling the common law rule, is saying we will encourage efficient breach. You cannot dangle that $18,000 as a penalty because it makes people stay in a contract that they should not be staying in. If the buyer decides he wants to buy a different house, let him out for the cost of damages and you can't keep the rest. But do not penalize him for staying because then he'll stay in a contract he does not want to be in. Yes?
I shouldn't have gotten.
Right, and so Catherine's saying, if that's the case, why didn't he sign the contract in the first place, right? That's a promise deal, right? And the response to that is people work on imperfect information. Maybe at the time he didn't realize it was a better deal across town. So there's always an efficiency argument pitted against a honor, promise argument. And these 2 points will not be resolved here. Right, so what did the court hold? The only retention of damages is what you actually incur, right? If you have a $35,000 deposit and your damages are $18,000, you can keep $18,000 and release the rest back to the buyer, and that's the most efficient manner. Yes, sir.
And this is, so that's the modern law approach.
Yes, sir.
Just discussed, and is that, mainly around the United States or majority?
Generally the unjust enrichment argument that Chase mentioned a second ago, that carries the day. And there is some intuitive appeal to it because why are we letting people benefit? Why are we letting them get more money than they should? Unfortunately, the promise is a promise rationale. That is on the way out. So as we've seen today in 3 cases, 3 common law rules reversed, always in favor of fairness, always at the cost of the seller. Ain't that something, huh? Omar, you're up next time, okay? All the way around. Any questions? All right, I will see all of you on Wednesday. Thank you.